You want your case to make some progress. You want your family law case to move forward. You want your divorce to just be over. Suppose that you've started a case. The other side has answered your petition, you answered their counter petition. You've exchanged mandatory disclosures, so what is the holdup? Well, if you cannot settle the case, perhaps the next most logical step is what we call family law mediation, usually done if you make less than $100,000 through a courthouse dispute resolution services. There are some amazing departments. Specifically, Lake County has a very nice department. Osceola and Orange have a very nice department. Even Hernando and Volusia counties, wherever you may go, traditionally have a terrific mediation department. But what are we exactly discussing when it comes to mediation and the timeliness of it? Therein lies the problem. If you have already exchanged your mandatory disclosures, you know the issues in the case. The case has not been settled or cannot be settled outside of mediation. Well, guess what, folks? Mediation is required in Florida. Unless the court dispenses with it, and Volusia County is the only county that I'm aware of that sometimes actually regularly dispenses with it, mediation is required. Is the process itself voluntary? Sure. Once you are at mediation, you can simply leave 2 minutes later. In fact, once attendance is taken, you do not even need to listen to the instructions of the mediator. You can hightail it on out of there, if that is what you choose to do. Personally, I believe that is inappropriate, and you should give mediation the full chance to succeed, to limit your future expenses in litigation, and to try to end your case reasonably and fairly. Nonetheless, the question remains, when should you go to mediation? Some people attempt mediation before the case even begins. I'm not really in agreement with that because you don't have all the information you need. But if you've exchanged your disclosures, again, you know the issues, you know what you want, you have a pretty good idea what they want, and you need some folks, whether it's the attorneys, whether it's the mediator, whether it's everybody, to talk some sense into people, maybe get you to the negotiation table so you can be in a situation where it can be resolved immediately under a certain time deadline, then you should absolutely go to mediation. I know some mediators that move mountains for people. They are unbelievable. I will not name names, but those that listen to the podcast that I'm familiar with, that I mediate with frequently, there are 5, 10 people we mediate with frequently. I'm sure there are thousands of mediators, but these folks are just amazing, the cream of the crop, the best of the best. They are so good at what they do. Very ethical, honest, reasonable, fairly priced, and fantastic. But again, what if you're ready for mediation and the other side wants to do unlimited discovery? Or they want depositions, or perhaps they want to just continue the case over and over and over, or outright refuse to go to mediation? What recourse do you have? In most cases, the proper course of action is to follow the Florida Family Law Rules of Procedure. Say that one 5 times. Florida Family Law Rules of Procedure. Rule 12.710. Referral by a presiding judge. The presiding judge may enter an order referring all or any part of your pending matter, i.e. divorce or paternity case, to mediation or some other form of relief, but it's typically mediation. Now, mediation is supposed to be attended expeditiously. These cases are supposed to be resolved in a reasonable time, in the fastest possible time that is reasonable. They're not intended to drag out for years unless absolutely necessary. Therefore, if you make a motion for referral to mediation, in most cases, there are no certainties in family law. Sorry to tell you, there are very few certainties in life, and family law is incredibly nuanced. But in most cases, that is the proper course of action. If the other side is non-compliant or refuses to go to the mediation table to at least give you a sense of whether or not your case can be settled or must be set for trial, well then, make your motion for referral to mediation, have a hearing, give the judge the names of your preferred mediators, and then try to get to mediation within a certain indefinite amount of time. That is typically the proper course of action. Having discovery happen and taking depositions and going ad nauseum through the pocketbooks of the litigants is perhaps not the best way forward, unless there's so much missing information that there's no reasonable alternative. Going to mediation is not only required, it typically represents the midpoint of your case, and it is the logical next step if you have enough information to proceed and know exactly how you would like to settle your case to seek to avoid a trial and any additional litigation. Thank you so much for listening. This has been another episode of the best Florida Family Law podcast. My name is Attorney Jonathan Jacobs of the Jacobs Law Firm. We are always delighted to speak with you about family law topics. Although this is not legal advice and we do not provide legal advice on our podcast, we certainly hope this has been informative and educational and that now you know a little something more about family law. Thanks. Bye.